relations and non-government, both in Europe and Africa. Dr. Mustafa holds a PhD in international relations and politics from the University of Leicester, UK, and has completed his graduation and undergraduate studies in Switzerland and Norway, respectively. He regularly contributes to the and authors articles and opinions, and his contributions have been cited in different news media outlets in 10 countries. In addition to this, professional experience and academic credentials, Dr. Mustafa is a mentor at the Geneva School of Diplomacy and International Relations in Switzerland and is a member of the Global South Network, a form of research, students, scholars, practitioners, civil society organizations from different regions of the globe. Today, Dr. Mustafa will be talking about the legal avenues for the realization of the right to self-determination. As we will be talking about the Kashmir, mostly the case of Kashmir. But before we give floor to Dr. Mustafa, about right to self-determination is a fundamental principle of international law that allows people to determine their political status, pursue their economic, social, and cultural developments. There are few legal avenues for realization, and we will see how Kashmiris can use these. These are the international treaties, conventions, United Nations resolutions. As far as Jammu Kashmir is concerned, we have United Nations Security Council resolutions for the rights of self-determination as General Assembly Protocol 15, 114, 1960, Resolution 260 to 5 of 1970, they also reaffirm the right to self-determination as has been enshrined in the UN security resolutions for Kashmir. Then we have seen after decolonization process, in that also International Court of Justice is there one more thing, and human rights, regional human rights instruments, and also civil society advocates and UN human rights systems. These are the avenues where the people who are under foreign and alien subjugation can pursue their case at international level. Now, how Kashmiris can use these all mechanisms, I will now request Dr. Balim Mustafa for his point of view. Doctor, you have the floor.
Many thanks to the moderator for this presentation. I don't think I have anything to add. I appreciate his very generous summary of my qualifications. Ladies and gentlemen, dear friends, dear brothers and sisters from Kashmir, good afternoon to all of you. I'm delighted and I see it as an honor to be amongst so many committed and dedicated experts and dignitaries. I'm happy to meet all of you virtually and to having this opportunity to share my insights and expertise regarding the legal avenues for exercising the right of self-determination in the 21st century. It is a subject that allows us to take stock of the political developments prior to, during, and after the end of the Cold War, and to reassess the current state of the modes of achieving and realizing the right of self-determination. When I was invited by Dr. Vani to lecture on this important subject, we discussed on several occasions while meeting in Geneva last month that the right of self-determination is gaining increased attention from states, governments, and decision makers. Since the end of the Cold War, we have witnessed the emergence of new states joining the United Nations like South Sudan and Timor-Leste, and other entities, although not becoming UN member states and whilst having their statehood contested, being able to act and function as de facto independent states. There are more than 10 contested states around the world, including Taiwan, Somaliland, Kosovo, Abkhazia, Transnistria. We can certainly refer to the post-Cold War era as the era of secession. Kosovo, for instance, has been recognized by nearly 120 states. Some weeks ago, Kenya and Sudan recognized its independence. Syria is reportedly going to recognize its independence too as well in the coming days. France has announced that it will recognize Palestine as an independent country. Ireland, Norway, and Spain did so many months ago. Mexico some days ago, to the dismay of Israel. Also, the UN Special Envoy for Western Sahara is reportedly planning to present a plan and a set of solutions for the settlement of the perennial dispute of Western Sahara between Morocco and the Polisario movement. So as we can see, there are many developments on the horizon in respect to self-determination, and for peoples aspiring for self-determination, like in Kashmir, these developments will have political and legal implications for the settlement of your dispute. So this is the political setting and context of today's lecture. I will structure my presentation in 3 sections. Firstly, I will provide a brief theoretical background about the notion of self-determination. Secondly, I will then discuss recent political developments regarding the exercise of self-determination in the 21st century and legal avenues for exercising it. Finally, I will open the floor for debate and questions and do my utmost to answer all of your queries and observations. Following on my brief introduction, a pertinent question emerges. What is the right of self-determination? Allow me to focus on 2 elements. It is the self aspect and determination. The right of self-determination, I will not go into too many details about legal sources regarding the scope and applicability of self-determination, but just allow me to mention some of them. Like the right of self-determination is upheld in Article 1, Paragraph 2, Articles 55, 56, 73, 74, and 75 of the UN Charter. It is recognized as a collective right within international law. Collective rights are rights that apply to groups, whereas individual rights are rights that we are entitled to as a person. Now, the primary rights holders of self-determination are peoples, whereas duty bearers remain states. What this implies is that peoples have the right to claim a certain set of human rights, fundamental freedoms, and related privileges that they are entitled to enjoy as a people or as a nation. This can be the right to speak their language, practice their culture, hold and exercise certain religious beliefs, display the national symbols, and engage in political activities to further the interest of their people or nation. As duty bearers, states have a particular obligation or responsibility to respect, promote, and realize human rights, and to abstain from related human rights violations and transgressions. Now, regarding the notion of people, this is understood as a group or community which possesses a certain degree of national consciousness and which can be distinguished from other groups by language, customs, and attitudes. The definition that is endorsed and used by UNESCO is the one outlined by Professor Michael Kirby. Quote, a group of persons with a common historical, racial, or ethnic identity, cultural homogeneity, linguistic unity, religious or ideological affinity, territorial connection, or common economic life. To this should be added a subjective element, the will to be identified as a people and that consciousness of being a people. A people must be numerically greater than just a mere association of individuals within the state, end quote. So therefore the self is the collective entity claiming the right to freely govern itself. And the self, as we've seen from this definition, must have a shared identity and shared political aspirations. Now, regarding the part pertaining to determination, the key question that divides political opinion is what ought people or the self to determine? For instance, the authorities in Pakistan have determined that we have to pay taxes. Obviously, we cannot refuse unless you want to go to prison, or if you want to live in hiding. The fiscal authorities will ask for their dues once a year, or I don't know how it is in Pakistan, but I assume that it is common practice around the world to ask once a year for payment of taxes. So in other countries, they do so it can be on a monthly basis or a year. But anyway, that is not important. The point I want to make is that it is the government that has the power to take legislative action on certain decisions. So the question about self-determination and what determination entails in the context of the right of self-determination can be answered by exploring international law, which lays down numerous obligations, duties, and set of rights that can be invoked by peoples to freely determine their political status and to pursue their human development economically, socially, culturally, and politically. This has to be achieved free of political subjugation, foreign domination, and exploitation interpretation by other parties, in this context by states or any other related central governments. So the understanding of self-determination takes nationalism as a starting point, and the premise that each nation should be entitled to their own respective state or a form of governance that allows them to achieve their political aspirations for self-determination. The ultimate goal, as practiced since the end of the First World War and until nowadays, was and is the establishment of a nation state for non-colonized people. Self-determination was therefore invoked as a political legal framing for manifesting claims to nationalism. This is also known as the Wilsonian self-determination, named after the US President Woodrow Wilson, the champion for the rights of nations to have their own independent states. But as we can see from the First World War, this was only applied to non-colonized people and not to colonized people. But this would change, and I will touch upon this subject in a couple of minutes. Now, the right of self-determination can be achieved in two ways. Firstly, in the form of internal self-determination. That means within the spheres of an existing sovereign country. This is often manifested through federalism or some form of autonomy or self-governance. That means the form of governance which is not completely in the control of a central government, but which provides or delegates a certain degree of freedom and flexibility to a people or a community to make their preferred form of governance more contextualized to their aspirations and needs. For instance, the United States have 50 states, and they have a great degree of freedom, besides defense and foreign policy, to run their own local affairs and provide certain services to their respective citizens. Secondly, and I think this is more pertinent in the case of Jammu and Kashmir, we have the notion of external self-determination, which implies that a group of people can establish their own sovereign independent country and undertake whatever political actions they wish and deem appropriate without any interference from a competing central government or a sovereign state. As per international law, notably the 1970 Friendly Relations Declaration and other related frameworks, this can be achieved, for instance, through the peaceful dissolution of a state. That means that the population in the country decides that it's in their best interest to no longer form one state. Czechoslovakia is an example of this category. It used to be one state, but then in 1990, it evolved into two states, Czechia and Slovakia, as we know them today. The same scenario unfolded in 2006 when Serbia and Montenegro split into two separate states, Serbia and Montenegro. Now, it can also occur that a territory wants to be peacefully associated with an already existing state. One instance is the example of the first Yugoslavia, where the Slovenes, Croats, and Serbs formed their joint state following the end of the First World War in 1914. The city of Trieste in Italy remained a separate entity until 1954, when its citizens decided to form part of Italy, whereas the easternmost part decided to join Slovenia. This was achieved through the holding of referendums. And finally, we have the establishment of an independent state through a secessionist act, and we have countless examples of this following the end of the post-Cold War, such as Sudan and Timor-Leste, as well as Croatia, Bosnia, Herzegovina, North Macedonia, and Montenegro. So the two first categories I mentioned, these are usually consensual. Okay, they are done with the consent and accord of the central government, whereas usually the establishment of an independent state is usually contentious. Now, allow me to add a fourth way of exercising self-determination, which is yet to galvanize political consensus among states. But it relates to the fact that subject to wrongdoings and wrongful acts of a state on a civilian population, including denials of autonomy, violations of human rights, the use of genocidal violence, secession can be enacted as a last resort remedy. This is contained in the Safeguard Clause, paragraph 7 of the 1970 Friendly Relations Declaration, and is often referred to as remedial self-determination. This is also a doctrine that has gained traction in the post-Cold War era and has been invoked by states to justify their decisions, for instance, to recognize Kosovo's independence, in the sense that for these states, particularly Western countries, the right of self-determination has witnessed an evolution to such an extent that in situations when a contentious self-determination dispute threatens international peace and security, a central government commits heinous acts and genocidal violence on a population and denies a people the right to exercise autonomy, secession emerges as a viable and acceptable remedy to the dispute. The advisory opinion of the International Court of Justice on Kosovo and the related oral and written statements submitted by more than 30 states debated the extent to which remedial self-determination is an acceptable norm. We can observe from these statements that many states, notably, again, I'd like to emphasize this, Western countries, were of the opinion that the principles of territorial integrity and sovereignty are not absolute and have to be balanced against key rights of international law, such as self-determination. So secession would, for them, emerge as a viable outcome in response to continued oppression by the territorial states, and when there is no expectation that internal self-determination could be meaningfully realized in the foreseeable future. So allow me to conclude briefly on this section. The determination part in respect to the scope of self-determination ranges from autonomy to full independence. Allow me to emphasize that it does not equate unilateral secession and has to be balanced against with
Hello, Dr. Mustafa.
Yes.
Can you have a slow speed?
I will do
so
that.
We can listen clearly.
No problem. Let me do that. Okay. Having this as the starting point, a pertinent follow-up question emerges. How can the right of self-determination in the 21st century be achieved? And what are the available legal avenues? There are several issues, and allow me to explore some of them. Firstly, secession can be manifested in a non-contentious or in a contentious manner. It is important to make this distinction from the very start of my presentation. There is much less political controversy surrounding non-contested instances of secession, as in principle, a sovereign state has agreed to a secessionist act of conduct invoked by a seceding aspiring entity. Consensual secession would therefore not violate the territorial integrity and sovereignty of the host state. For instance, Quebec, a region in Canada, held an independence referendum in 1995. The majority of the population voted against, but had the independence movement won, Quebec would have been today an independent country. Canada already gave the green light for the referendum to take place. Other examples we can refer to of similar nature is the independence referendum of Scotland in 2014. Here again, the population voted against secession. In 2019, Bougainville, which is a territory within Papua New Guinea, which is a country in north of Australia and east of Indonesia, voted for independence. More than, I think it was 97% of the population that voted for secession. And the central government gave its accord to this, and the parties are now negotiating on how to allow Bougainville to separate. And it is estimated that before 2030, the negotiations will be finalized and the country will join the UN. Then we have the situation of a contested act of secession, which involves the separation from a territory without the approval of the central government. Obviously, such a situation results in civil disorder and violence, as it includes the withdrawal of a sovereign state's right to administer a territory and the exclusive right to impose its political and legal authority on the territory's inhabitants. Contested secession fundamentally impacts a state's sovereignty and territorial integrity and can undermine the stability of the state system if one would allow for a general right to secede. Examples here are Crimea, we have the Donetsk and Luhansk People's Republics in Ukraine, Gaza, Kosovo, Northern Cyprus, South Ossetia, Abkhazia, and the list can just go on and on. Huh? Now, in respect to the legal avenues of achieving self-determination, they are, in principle, as follows. Firstly, decolonization of colonized territories and foreign occupation were tantamount to external self-determination until the late 1990s and until today, to some extent. During the Cold War era, the United Nations undertook an ambitious political effort to facilitate the decolonization of territories and to apply the right of self-determination to colonized peoples who were subjugated for decades to foreign colonial administration, illegal occupation, and domination as stipulated, for instance, by the 1960 UN Declaration on the Granting of Independence to Colonial Countries and Peoples. The territories that were designated as colonized were referred to as non-self-governing territories, and the colonizing powers had the obligation to put in place a political process conducive to their decolonization as per different international legal instruments and frameworks like the UN Charter and the 1970 friendly decided to remain part of France. Now, the three other neighboring islands declared in the remains the only recognized non-self-governing territory whose territorial status remains disputed. One can also add Jammu Kashmir to this list, given that the UN Security Council in Resolution 39 of 1948 has called for the holding of a referendum to determine its final political status. As such, Jammu Kashmir is likewise considered a disputed territory. Now, many of you might think that colonial self-determination is no longer relevant due to the fact that the UN's decolonization efforts were concluded in 1994 with Palau's entry to the UN. One would assume that the legal language pertaining to decolonization would be updated, modified through the adoption of new legal frameworks that would be more pertinent to non-colonial acts of secession in the post-Cold War era, given that the restrictive colonial interpretation of self-determination had become obsolete. Despite this, no steps have been taken so far to reassess the scope and viability of colonial self-determination in the post-Cold War era towards non-colonial acts of secession. This is related to the fact that some states advocate in favor of respecting and upholding the principles of territorial integrity and sovereignty in the sense that they are absolute, which implies that states are in full control of their geography and have the capacity to govern themselves independently without interference from a third party. Also, many states fear that allowing for non-colonial secession would open the possibility for a general right to secession and therefore precipitate the fragmentation of many states and incite secessionist movements to take up arms. This was the general view that prevailed among the UN and the majority, if not all, sovereign states during the Cold War. For these reasons, a limited right to colonial self-determination was achieved to the opposition of many colonial powers like Portugal, that fought many civil wars in Angola, Mozambique, and Guinea-Bissau against liberation movements. Conversely, and this is very important, especially when we look at state practice in the post-Cold War era, there are a large number of states, particularly Western countries, that have advocated in favor of a right to humanitarian intervention through the use of military force and related coercive and political diplomatic measures in response to grave human rights violations inflicted on civilians and people in internal conflicts, and when such situations constitute a threat to international peace and security. This is the path to remedial self-determination, or what some experts have referred to as conditional self-determination. That implies that secession is not a general right that can be claimed and invoked by seceding aspiring entities, but they would have to go through some form of scrutiny and assessment to, in a way, prove their respective cases and to build the necessary political momentum in favor of secession. For many countries, in situations where a contentious self-determination dispute threatens international peace and security, states have the right for moral and ethical reasons to intervene and change the status quo and facilitate a process conducive to secession. This has been witnessed in Timor-Leste and in Kosovo, with the military interventions undertaken in 1999 by a host of states against Indonesia and Yugoslavia, respectively. So a broadening of the right of self-determination to include non-colonial acts of secession came also with the breakup of Yugoslavia and the Soviet Union in the 1990s, which resulted in the establishment of more than 20 sovereign states. With the end of the Cold War, both states entered a period of fragmentation and dissolution. In the case of the Soviet Union, the secessionist path went in principle peacefully, but in Yugoslavia, things were more tense. Long story short, UN member states recognized ultimately the republics from the former Yugoslavia that seceded, and the UN admitted these territories as member states. The European Commission, today's European Union, they issued what is known as the Badinter opinions, which were a set of conditions and criteria the European Union imposed on territories that seceded in order for them to secure recognition from the EU and its member states. So from these developments, we can therefore observe a broadening of the modes of achieving self-determination as non-colonized territories were able to secede and ultimately join the UN. Obviously, these developments contradict and challenge the conventional understanding of international law, which considers states to constitute the main subjects of international law, and that related principles and rights, such as territorial integrity and sovereignty, have a superior status to other related principles and rights. Notably, these dynamics and contradicting perspectives have significantly amplified in the post-Cold War period, which demonstrate how perceptions of states are shifting back and forth, in some instances towards a more favorable approach towards human rights protection of civilians in armed conflicts, whereas in other instances in favor of maintaining status quo. So from the end of Cold War, it can be concluded that at a time when it remained unimaginable from a political standpoint to condone a general right to secession during the Cold War period, the post-Cold War era demonstrated that secession could be warranted under favorable political circumstances and would no longer remain unfeasible. Allow me very briefly to emphasize that there were attempts of non-colonial secessionist acts during the Cold War era, but they largely failed, as was the case in Biafra, Nigeria, or secessionist attempts were condemned by the UN Security Council as illegal, as evidenced in Katanga, at that time Zaire, today's Democratic Republic of Congo, South Rhodesia, today's Zimbabwe, and Northern Cyprus. The only successful case of secession during the Cold War era that was not related to to the colonial process of achieving self-determination was East Pakistan, known today as Bangladesh. Now, in the post-Cold War era, what is surprising to observe is that similar acts of secessionist attempts would not be condemned by the UN Security Council and its permanent members as illegal. Many territories which have seceded but remain unrecognized and unable to join the UN, they enjoy bilateral political relations with existing sovereign states. So this is a major shift in the thinking and perception of states regarding secession compared to the Cold War era. As I've mentioned, and allow me to repeat this again, Kosovo, for instance, has been recognized by almost 120 countries, despite the fact that its statehood remains opposed by Serbia and Russia and China. Recognitions have also been conferred on South Ossetia and Abkhazia by countries like Venezuela, Nicaragua, and Russia, although these territories are claimed by Georgia. Taiwan as well continues to live its own life, independent from China, enjoying recognition from different countries and maintaining bilateral and political relations with governments around the world. So to summarize, from these political developments emanating following the end of the Cold War, we can observe that international law and its continued relevance and application would come under scrutiny. So the right of self-determination would be on a collision course with the principles of territorial integrity and sovereignty, and this would very much influence international politics and diplomacy. Besides the fact that military humanitarian actions bypassing the UN Security Council violate international law, one has to mention this. Many of these interventions were undertaken sometimes arbitrarily and sometimes on an ideological basis. Countries considered, for instance, non-democratic, non-Western, non-liberal would often witness regime change and internal chaos, like we saw in Libya and Iraq. Whereas at the same time, other dictators and cruel leaders that were much more congenial to the political interests of Western countries would, for instance, escape sanctions and allowed to pursue their political agendas. One example is Gaza, and one can add many more countries to this. Now, a final avenue for achieving self-determination is through autonomy and self-governance. So the idea of constitutional self-determination or internal self-determination is to govern itself within the framework of an existing state without seeking full independence. It emphasizes on autonomy, self-governance, and meaningful political participation while respecting the territorial integrity of the state, as such a modality operates within the constitutional order of a sovereign state. Now, there are some examples of territories that enjoy a great degree of constitutional self-determination. You have the example of Scotland, we have Greenland, and Catalonia. So in addition, territories that aspire for independence but are unable to achieve this militarily or with the support of the international community tend to find a middle ground with opposing parties to a dispute. We have the example of, as I mentioned earlier, Bougainville, that agreed to be reintegrated with the host state on the condition that the central government would allow for the holding of an independence referendum. And both parties went through a terrible civil war that lasted for more than 20 years, that left many people dead. A similar approach was also used for the settlement of the dispute in South Sudan, where the political leaders of Juba or South Sudan agreed to be reintegrated into Sudan for a very short period on the condition that Sudan or Khartoum would allow for the holding of an independence referendum. This was achieved in 2011. In Western Sahara, the 1990 settlement plan that was accepted by both Morocco and the Polisario movement included a two-step process to address the dispute. Firstly, the territory becomes part of Morocco, and then secondly, through a referendum, the people of Western Sahara would choose between independence or integration with Morocco. Now, this is yet to happen, unfortunately, and the UN Special Envoy's proposal for Western Sahara in the coming weeks or months will be important to follow to see what he proposes on this subject. This will most certainly set a precedent for the trajectory of addressing the dispute of Jammu Kashmir. So these are the most imminent legal avenues for achieving self-determination: the decolonization path, the remedial or conditional self-determination option, then, as I mentioned, internal or constitutional self-determination, and the hybrid model. We agreed to reintegrate if you allow us to secede eventually in the future, should a referendum support this claim. Now, last point, we also have the concept of indigenous self-determination, which focuses on autonomy, land rights, and cultural preservation within existing states of indigenous groups. I will not expand on this, given that its concept and meaning is irrelevant to the topic of today's discussion. Now, last point. In the future, one may consider adding a fifth way: annexation, as we have seen in Ukraine with Russia's actions, and perhaps US with its future action of Greenland that belongs to Denmark. However, I believe in the principle of ex factis non oritur jus. No law emerges out of unlawful acts, and I therefore do not consider annexation to be an acceptable practice, and this is also a view that is supported by most states, to settle claims for self-determination. However, might is right, and great powers can sometimes take whatever decisions they want and not be held accountable for any wrongful acts. Now, the point I want to make is that we have seen many examples of annexation in Ukraine, and perhaps in the coming years in Greenland. Let's assume that US annexes Greenland. We cannot ignore the political implications of such acts, and that other countries may follow in the same direction. Tomorrow, Turkey can annex Northern Cyprus. Azerbaijan already retook Nagorno-Karabakh, and other countries may use military force to recapture territories. Moving to the last part of my lecture, a final question I will examine is: through what processes can seceding aspiring entities, in particular Jammu Kashmir, address their claims for self-determination? Firstly, from the standpoint of decolonization, and as the potential status as a non-self-governing territory, I do believe that Jammu Kashmir has a compelling case. Pakistan, I know, has largely argued that Jammu and Kashmir is a disputed territory under foreign Indian occupation and qualifies as a non-self-governing territory under UN Charter Chapter 11. It has cited on several occasions UN Security Council Resolution 47 of 1948 and subsequent resolutions which called for a plebiscite to determine Kashmir's future. Such claims have also been presented to the UN Fourth Committee, also known as the UN Decolonization Committee. India, on the other hand, rejects this classification owing to the 1947 Instrument of Accession, and that according to New Delhi, the 1972 Simla Accord framed Kashmir as a bilateral issue between India and Pakistan. So for these reasons, India claims, among many other arguments, that the right to self-determination under UN principles applies only to colonial contexts, not to sovereign states. Now, what we can conclude is that the UN recognizes Kashmir as a disputed territory. This is true, but it has not listed it as a non-self-governing territory. The UN's Fourth Committee has discussed Kashmir under decolonization, but no formal action has been taken. Again, as I have emphasized, I believe the colonial right of self-determination is obsolete. It is no longer pertinent, even if Jammu Kashmir would be listed as non-self-governing territory. I am not convinced that this would facilitate in the long run a political solution to the dispute. Western Sahara is already listed as a non-self-governing territory. It has been so for more than 40 years, and the situation has reached a political deadlock. I just read some weeks ago that Marco Rubio, the foreign minister of the US, sent a message to the government of Morocco reiterating that the US recognizes Moroccan sovereignty over Western Sahara, despite the fact that it's considered by the UN and its member states as a colonized territory that is entitled to decolonization. So let's assume hypothetically that Jammu and Kashmir would be listed as Pakistan is insisting as a non-self-governing territory. I don't think this would change much in the long run, as most likely this would not compel or convince India to allow the people of Kashmir to exercise, to manifest their rights for self-determination. So this takes me to the second point. I would advise assessing state practice and related customs, in particular recognition policies that have been announced by UN member states regarding non-colonial acts of secession in the post-Cold War era. Why do states recognize contested territories? And to support their recognition policies, what factors or conditions do they invoke? Are they recognizing these territories because international law, the way it has evolved after the end of the Cold War, allows them to do so? Or is it due to the fact that international law supports non-colonial, different modes of achieving external self-determination that is not related to the colonial path? Is it remedial self-determination? What is it? How has international law evolved, and how is it that states considers its scope and applicability to be relevant to non-colonial acts of secession? So in my book, I have assessed the recognition policies of UN member states towards Kosovo and Timor-Leste, and very few, if any, countries considers, for instance, the colonial right of self-determination to be relevant. Instead, as I have observed, attention is being addressed towards the fact that since the end of the Cold War, contentious self-determination disputes are no longer considered domestic conflicts, but instead they constitute violations of fundamental principles and rights of international law that allow the UN and influential states to hold these violators accountable for their wrongful acts. In the case of the US and Western allies, secession has been supported for Kosovo, South Sudan, and Timor-Leste. In the case of Russia, they have supported secession of Crimea, Eastern Ukraine, Abkhazia, and South Ossetia. And all these entities, they benefit from the support of these states owing to conditions similar to remedial self-determination. Now, both Russia and the US and many other Western countries, they have supported the right to secession for territories on the condition that they've gone through a forceful annexation, denials of autonomy, human rights violations, genocidal violence, and the fact that involved parties were unable to find a peaceful solution. Now, it may sound perfect like on paper, but there are several obstacles that holds back remedial self-determination from taking effect. Allow me to mention some points, and then we can discuss them further. Firstly, given that international law continues to endorse a colonial right to self-determination, remedial self-determination remains vague from a legal standpoint. There are no frameworks that supports its application and remedial secession from taking effect. Secondly, remedial self-determination is not self-executing in the sense that once a territory reaches the threshold, the UN will intervene and propose a solution. Thirdly, whenever violations and transgressions are made, the lack of enforcement mechanisms to hold states accountable result in a climate of impunity where powerful states can get away with international law violations. For instance, who is going to hold Israel accountable for its actions in Gaza? The US is trying, the UN is trying, and so do certain member states by condemning these actions. But at the end of the day, many countries are able to get away from these situations unpunished. Fourthly, given that remedial self-determination requires a degree of support from a third party, ideally a great power, there must be an international consensus that a particular contested territory can become independent. Now, in the case of Jammu and Kashmir, if you look at the academic literature regarding your cause and remedial self-determination, there is unfortunately insignificant literature and material on this matter. So sensitizing the academic community about this matter is important in the years to come, so as to build a movement of support for Jammu and Kashmir from the perspective of remedial self-determination. This may not change the situation on the ground immediately, but it would most certainly influence decision and policymakers, as well as the general public in many countries, about your cause. The point I want to make is that, given the political precedents that have been set, is your case different from what we experienced with Russia's invasion in Ukraine? An obvious answer is, oh, you're not backed by Moscow. True, but state practice and customs contribute to the development of international law as upheld in Article 38 of the ICJ status. So the next question should be, or the next step would be, to consult the International Court of Justice and request the court to issue an advisory opinion regarding the self-determination dispute in Kashmir, the binding character and effectiveness of remedial self-determination, and proposed remedies to settle the dispute. Thirdly, in respect to internal self-determination, is there a way for Jammu and Kashmir to be able to accommodate their aims through self-governance without the need to disrupt the territorial integrity of India? I believe the current status, in which India has effectively abolished Kashmir's autonomy, will worsen the prospects for achieving durable peace and security in the region. India is also undergoing significant economic growth, which will make them much more assertive militarily. This is a fact that one cannot ignore. However, let's assume, for the sake of discussion, that India would hypothetically reverse its decision one day. How would a possible settlement balance between autonomy and a legally entrenched commitment to India's territorial unity? There are many examples, especially in Europe, where these goals go perfectly well, and both parties should look into possible modalities for achieving their views. In Italy, the region of South Tyrol, inhabited by Germans, enjoy autonomy, their own government, and the right to use the German language. Similar arrangements have been made for Catalonia and the Basque region in Spain. In North Macedonia, through constitutional changes made in 2001, through the Ohrid Framework Agreement, the Albanians enjoy special rights and privileges, where they make up more than 20% of the population. Same for Hong Kong and Macau in China, Chechnya in Russia. So the point I want to make is that in situations of political deadlock, trading self-determination for autonomy and self-governance could be a way forward from a short-term perspective, and something to be considered, especially when engaging with powerful regional superpowers. States and contesting parties can come to terms regarding their joint future and the most viable modes of achieving their common political interests and aspirations through dialogue and consensus. The model used for South Sudan and Bougainville are certainly worth looking into, given that this method of addressing secessionist conflicts is gaining traction. In other words, we accept autonomy for a short period on the condition that an independence referendum is allowed to be held in the future. We see, for instance, a similar accommodation being made in respect to Greenland, where Denmark have granted the island substantial autonomy, and has at the same time expressed its willingness to allow the people of Greenland to decide their own political future. we should most certainly also follow the developments of Western Sahara, as the proposals from the UN for the settlement of the dispute will have implications for the settlement of the Kashmir conflict. Will it be supervised independence for the people of Western Sahara in the next 10 years? Will the territory be divided among Morocco and the Polisario movement, or will the UN suggest autonomy? So I think this is very important to follow these developments. Same also for Ukraine. What solutions will be proposed for the Russian-speaking territories? Will they be returned to Ukraine, or will referendums be held, as some media outlets have claimed, to address the territorial status of the annexed regions? To conclude, and given all of these observations made so far, there are potentially some measures to consider in order to sensitize the world opinion about your claims to self-determination, enhance the prospects of peace, and to accommodate competing political ambitions. Firstly, I am in favor that states and oppressed parties settle their claims through dialogue and mediation. The most efficient way to do so would be to request the International Court of Justice to issue a non-binding advisory opinion regarding the self-determination status of Kashmir. I believe that such an avenue would allow the ICJ to take stock of the current political developments in the region, elaborate on potential solutions for the conflict, its status as a colonized or a non-colonized territory, and remedies the people of Jammu and Kashmir would be entitled to according to international law. In addition, pending matters such as the relevance of the Simla Agreement and Article 370 nullification should be brought to the attention of the ICJ. Many countries have gone through this path, as did Kosovo and Serbia, when the ICJ ruled in favor of Kosovo's independence in 2011. In the case of the Chagos Islands between UK and Mauritius, the ICJ claimed that the process of decolonization was not lawfully completed after Mauritian independence in 1968, and that UK's continued administration of the islands constitutes a wrongful act. Both UK and Mauritius are now negotiating the settlement of this dispute, which will most likely result in the islands being returned to Mauritius. Venezuela also holds claims to the western region of Guyana, known as Essequibo, and the ICJ is currently assessing this case. So why not Kashmir? I think that the ICJ should address this matter as well and act as a neutral arbitrator. Allow me to also mention that claims of human rights violations and to build a compelling case in favor of remedial self-determination can be presented to human rights treaty bodies and their related complaint committees. Some of them are the Committee on the Elimination of Discrimination Against Women, Committee Against Torture, Committee on the Elimination of Racial Discrimination. Also, most of the core international human rights instruments have their own monitoring bodies. You also have the Universal Periodic Review, where states undergo a peer review of its human rights records. The Human Rights Council also has a similar complaint committee. There is also the possibility to inform and sensitize UN special procedures and mandate holders about violations of self-determination. And these monitoring bodies can also act as neutral arbitrators, offer a sense of guidance on possible remedies for human rights violations and transgressions. Debates can also be initiated at the UN General Assembly, at the UN Security Council, although the latter is a bit more problematic because of the veto power of permanent members. And you also have, finally, the possibility of relying on third-party mediation, as we see in Ukraine with the involvement of the US. However, states often tend to reject such requests, as they would, from their perspective, constitute interference in their domestic affairs, but sometimes breaking the ice and facilitate dialogue require the involvement of a third-party mediator, which can also be the United Nations. So the point I would like to make is that it is important to avoid that self-determination evolves to become a zero-sum game during which the winner takes it all and the loser has to accept a humiliating political defeat. Foresight is imperative to develop a stable and peaceful international world order. As so often in international law and politics, only a balancing act of competing rights and principles will ensure sustainable relations. Also, a final condition for the improvement of the political situation in Kashmir remains political relations between India and Pakistan. While both countries maintain antagonistic relations, it is unlikely that both countries will agree to a lasting and durable solution to the situation in Kashmir. And we can observe this with the arrival of Modi and some of the unilateral decisions he has taken. So what we need is a form of Good Friday Agreement, like we saw in Northern Ireland, a political process which aims at diffusing the political situation in the region, restoring the autonomy status, providing enhanced degree of autonomy for the people of Kashmir, and allowing the people of Kashmir to decide their own political faith as per their aspiration and needs. So again, allow me to conclude one final sentence. No single method guarantees success, but combining diplomacy, legal mechanisms, peacekeeping, and local engagement offers the best path to resolving conflict. I thank you.
Thank you, Dr. Mustafa, for a very wonderful and detailed presentation on the lawful avenues for the right to self-determination, as you illuminated on different types of self-determination and the case studies of the external self-determination, internal self-determination, and annexation, and many other autonomies and other things which have happened around the globe, and the cases which are presently there. Thank you that you told us that it's the wholesome work which can make a success in this field, that is that international treaties and conventions, United Nations resolutions, decolonization process, ICJ, regional human rights and legal legislation, civil society, and using all international human rights mechanisms and tools. And that is how we can have the desired results for the right self-determination. As for Kashmir, I think we have some people. If they can have a question to Dr. Mustafa, please raise your hands and you can ask a question. Anyone? Is there anyone? I think there's no one as yet. I will wait for them. If they have any question, we have left with some 5 minutes. I will now request Dr. Mustafa. Just I want your clarification on one thing. Though you... Parvez Shah. Yes, Parvez Shah Sahab. Parvez, unmute yourself. Parvez Sahab, unmute yourself. Parvez Sahab, you are muted. Please unmute yourself. हमारे पास नहीं है. Yeah, okay. Okay.
Good afternoon, Dr. Mustafa.
Good afternoon.
Thank you very much. Last time I heard you in Geneva also, and it is a pleasure for me that I'm listening you again. And you have made number of clarities. I have just a small question, and you will just clarify that in 1947, when the subcontinent was divided, and the ruler of the Jammu and Kashmir, that was a princely state, signed an agreement that's called Instrument of Accession.
Yes.
Instrument accession with the government of India. And however, the government of India took the matter when this accession was not accepted by the people, and there was a resistance. He took the matter to the United Nations, and we had number of United Nations Security Council resolutions giving the right to self-determination to the people of Jammu and Kashmir. The question arises that how valid is that agreement, and what is its evidentiary value at the United Nations, or does this document has any international validity on the basis of which India claims that the ruler has acceded with the Union of India? Did you follow me?
Yes, I followed you. Well, I mean,
and secondly, the question of recognition. Because there has been almost India has been inviting different international diplomats to the disputed territory, and at the same time he had 20
I cannot hear you very well.
Yes,
let's wait maybe a minute.
Yeah. Dr. Mustafa.
Yes.
You respond to this question, as we are left with only a few seconds now.
Yeah. Well, I think the instrument of accession, I think, its validity is relevant in the sense that it was accepted by both Pakistan and India in the sense, as we can see as well with the 1972 Simla Agreement, which accepted de facto and de jure the line of control. So in a way that facilitated the division of Jammu and Kashmir. Again, we just have to take into consideration the legal language that is contained within the UN Security Resolution of 1948 that refers to the status of Jammu and Kashmir as disputed. So again, as per international law, once we consult the legal frameworks in regards to the settlement of disputed territories, for instance, the 1970 Friendly Relations Declaration, I outlined the methods of determining the status of disputed territories, and it is the rights holders that must have the last word. In this case, the people of Kashmir, and obviously the status of Jammu and Kashmir has not been determined or settled. It has been settled according to the wishes and desires of India through the abolition of Jammu and Kashmir's autonomy. So therefore, the status of Jammu and Kashmir continues to remain disputed, and India is obliged to determine its status. Otherwise, we enter into a debate whether Jammu and Kashmir has been annexed, and annexations are illegal according to international law. Therefore, for instance, if we just refer to the 1970 Friendly Relations Declaration and its text, it stipulates that the territory of a state shall not be the object of acquisition by another state resulting from the threat or use of force. No territorial acquisition resulting from the threat or use of force shall be recognized as legal. So I think this very much reflects the current status of Kashmir, and I don't think India can claim that it has settled the political future of Kashmir without consulting the views of the constituents, the people of Jammu and Kashmir. So I think that international law and state practice is very clear on this. And again, if an annexation is deemed a threat to peace, the UN Security Council can impose different sanctions. Again, yeah. So that's how I see the current status of
Thank you, Dr. Mustafa, for your response to this question. And as we know, India's last action in Kashmir was an annexation. Again,
Yes.
the first one also, in a way, they took the control of Kashmir and thus showing the instrument of accession. But to me, then they surrendered it to the UN Security Council when UN Security Council came with the resolution on Kashmir, that is the people of Kashmir to decide their political future. And likewise, the another illegal activity which they did was the annexation of Kashmir on 2019 by annexing Kashmir again. So
Yes.
with this, we have very limited time. You have raised many you have clarified many misconceptions about the right self-determination, and you have also elaborated on many things where we can make our case for this right self-determination in different ways, in different international bodies, and also at the United Nations Security Council, Human Rights Council, UN, ICJ, and other treaty bodies. Thank you very much, Dr. Mustafa.
Allow me to make one last observation very briefly about annexation, because the International Court of Justice has issued several advisory opinions related to denials of autonomy. For instance, in the Western Sahara advisory opinion, the ICJ ruled that the Sahrawi people possess the right to self-determination, like the people of Kashmir. And in the case of Western Sahara, Morocco's and Mauritania's claims of historical sovereignty, which is very similar to what India is ascertaining, were insufficient to override this right. This was therefore an affirmation that autonomy, self-determination cannot be suppressed by external territorial claims. And then finally, in addition, the Chagos advisory opinion of 2019, again, the ICJ affirmed that UK separation of the Chagos Islands from Mauritius and during decolonization and expulsion of the Chagosians to build a US military base was unlawful. For this reason, the court concluded that the UK was obligated to end its administration of the island, quote, as rapidly as possible. And this conclusion reinforces that denying autonomy to a people is illegal, even in the case of Chagos, even decades after decolonization. That is why I emphasized requesting the ICJ advisory opinion to issue an advisory opinion on Jammu and Kashmir to touch upon the numerous matters we raised, annexation, denials of autonomy, remedial self-determination, I think is essential. And even if the ICJ would rule in favor of Jammu and Kashmir, it will not change the situation on the ground, but it will constitute a major political victory to sensitize world opinion about the wrongdoings that happens in Jammu and Kashmir. This is for me really the key forward. We can discuss, have webinars, we can bash each other, no problem, but it will not precipitate the solution to the territorial status of Kashmir and its future. Requesting the ICJ to act as a neutral arbitrator is the way forward. Why this hasn't been done until now, for me, I have to admit, I'm a little bit surprised. I think now is the best moment to do so. Because it's again, you know, we have a neutral arbitrator that is just there to give opinions and advice. And once you have the ICJ advisory opinion, then the parties can negotiate like proper human beings, come with solutions. You know, we cannot force marriage on a couple that doesn't want to live together. Sometimes we just have to admit that it's best to separate if that is in the long-term interest of involved parties. And I do believe that the ICJ can diffuse the existing political tensions, provide much more clarity on where the issues are and what remedies, solutions can be proposed to the people of Jammu and Kashmir. That's it.
Thank you, Dr. Mustafa, for sparing your time for us. Thank you very much for being with us.
Thank you as well.
But we will keep on touch and we will keep on sharing benefit from your knowledge in future also. Thank you so much.
Thank you.
Thank you.
Thank you.